All right, hello there. My name is Luke French. I'm volunteered to present the Group 1 legal cases on behalf of myself and my project partner, Reggie. So, starting off with case 1, we have Wisconsin versus Yoder, 1972. Essentially, three Amish students stopped attending their high school in Wisconsin due to their parents' religion. One of the fathers represented the families in the case. Wisconsin convicted them and they were fined. Upon appeal, Wisconsin Supreme Court ruled in Yoder's favor. Wisconsin appealed this to the Supreme Court and lost. The ruling, the U.S. Supreme Court found that the Amish children could not be placed under compulsory education past 8th grade due to the religious freedom outweighing the interest of the state. Our commentary on this, although education is important and states have the best public interest often, constitutional rights cannot be overruled by issues pertaining to public education. And in this case, specifically the Free Exercise Clause of the First Amendment, which states that Congress can make no law respecting an establishment of religion or prohibiting the free exercise thereof. Okay, our second case was Meyer versus Nebraska in 1923. We have a teacher, Robert T. Meyer, in Nebraska. He was found reading a Bible in German to a student. The county attorney found this out and he charged him with violating the Simon Act, which was passed after World War I because of anti-German sentiment following the war. The U.S. Supreme Court ruled that the Simon Law, which prohibited minority language, violated the Due Process Clause of the 14th Amendment. All right, so the Simon Act was a clear violation of the Due Process Clause of the 14th Amendment, which states that the government cannot deprive a person of life, liberty, or property without due process. Our third case, Tinker versus Des Moines, 1968. 5 students in Des Moines, Iowa. They decided to wear black armbands to protest the Vietnam War. They were suspended. The U.S. District Court upheld the decision of the Des Moines School Board. This was appealed all the way up to the Supreme Court. The Supreme Court ruled in favor of the students. It was deemed that the First Amendment applied to public schools, and without a valid reason, schools cannot regulate free speech. All right, the commentary. Essentially, it could be boiled down to this statement from the Supreme Court, who said that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Okay, case number 4, special education case. We chose Brown versus Board of Education, which I believe is a very famous case. This happened in Topeka, Kansas, when the public school system refused to enroll a local black student named Oliver Brown. And they wanted to bus her to a segregated school further away. The Browns, as well as 12 other families, they filed a class action lawsuit in federal court against Topeka Board of Education, alleging that this was unconstitutional, and the Supreme Court agreed with them and ruled that public segregation was in fact unconstitutional, even if the schools were deemed equal in quality. Okay, why is this important to special education? Is in addition to segregation, this case also provided parents of children with disabilities and disability rights activists the constitutional foundation to push for equal opportunities for all children, including those with any sort of disabilities. Okay, our fifth case that we chose was this one's focused on students' rights, Hazelwood School District versus Kuhlmeyer, 1988. 1983, at Hazelwood East High School in St. Louis, the principal removed two articles from the paper called The Spectrum. The articles covered issues such as divorce and teen pregnancy. The student journalists sued over the violation of their First Amendment rights. A lower court sided with the school, which was overturned by the Eighth Court of Appeals. Um, the Supreme Court reversed this ruling, and they noted that since the paper was part of a program established by school officials, it was a controlled forum and could be supervised. All right, our commentary. Although the students do have the right to free speech in or out of school, schools can limit some speech in official forums if the school deems these actions are reasonably related to pedagogical concern. So, meaning they can restrict things that they feel may disrupt the learning environment. All right, case 6, a law case focused on teachers. We chose Pickering versus Board of Education, 1968. Marvin Pickering, who is a teacher in Illinois, he wrote a letter to the local paper criticizing some of the school district's decisions in regard to bond issues and other things. He criticized the superintendent for attempting to suppress teachers from speaking out. He was dismissed by the school board over this letter. The ruling was that the Board of Education rejected that his letter was protected by the First and 14th Amendment. The Will County Court and the Supreme Court of Illinois upheld this. However, the Supreme Court ruled that his First Amendment right to free speech was violated. Our commentary, this case established the precedent that public employees do not lose their right to free speech or to speak on matters of public concern simply because of their employment by the government. Okay, the significance. These are some of the reasons we found these cases to be significant. These cases are significant because they establish and uphold constitutional rights for students, families, and teachers. Brown versus Board promoted equality. Tinker versus Des Moines showed that schools must maintain order while at the same time respecting free speech. Wisconsin versus Yoder was significant for religious freedom. Meyer versus Nebraska highlighted the importance of language rights and protected against reprisal without due process. Hazelwood versus Kuhlmeyer showed that schools could limit some speech related to the learning environment. And Pickering versus Board showed that teachers maintain their First Amendment rights even if they are a government employee. Collectively, these highlight that there's often a fine line that must be walked between the interests of the school and the interests of protecting individual rights. All right, the ramifications for today. Many of these cases influence policies that support equality, free speech, and individual rights. These cases allow current day issues such as inclusion, fair treatment, freedom of speech, and freedom of religion to remain relevant. Many of these cases emphasize how the education system must accept and accommodate people regardless of background, ability, or religion. And finally, these legal decisions highlight how important it is for educational establishments to maintain that balance between the interests of the school and individuals' constitutional rights in order to have a learning environment that respects freedom, diversity, and equality. Thank you for viewing this presentation. Here are our references, and that is all.